Special counsel Jack Smith wants Donald Trump gagged. And he wants this done immediately. He doesn't even want argument about it. He says, Judge, we've already made our case. You don't even need to hear from them. Just go ahead and enter this order so that we can get this done. We've got all of this discovery that we're ready to just drop off at Trump's house. And so if you grant this without Trump's input at all, without even having a hearing on this, everybody's going to be happy. And Trump's so stupid that he doesn't even know that what we want is best for him. And so the judge said, all right, hold on a minute. You guys need to meet and confer before I just start entering this stuff on my own. Give me a couple dates. And so they did. The government and Trump's people got together and came up with dates for the next meeting where they're going to argue about this gag order. So we'll look at that first. Here is the notice. 2-page filing coming out August 8th, United States of America versus Donald Trump. And this is a jointly signed notice. You see Trump's lawyers are signing down here. John Lauro, we've heard a lot from him here on this channel, along with the special counsel's office, Thomas Wyndham and Molly Gaston. So they jointly submit this filing. They say, hey, Judge, on August 7th, you directed the parties to meet and confer and then respond to us and inform the court by a joint notice, which is what we've got here, of 2 date and times on or before August 11th when both parties, Trump's team and the special counsel, are available. The parties have conferred and hereby provide notice. They say the government is available at any time August 9th, 10th, or 11th. So that's going to be Wednesday, Thursday, Friday. We're available. And the government, of course, is always available, especially in this case, because this is all they do. They really have nothing else to do. These prosecutors, I would imagine, this is their entire life for a long time, and they have, nothing really else important going on. So they're like, no, we're available. I mean, when we're not working on this, we're trolling Trump's truth posts and, stuffing our face with junk food. Prosecutors have a lot of snacks around. That's why they look like that. The defense represents the following. President Trump will not appear, right? He doesn't need to be here at this hearing. However, he would like to have both his counsel, John Lauro and Todd Blanche, at the hearing. Both of them, he wants them to be there. As is his right, he's a defendant, right? He wants his attorneys to be there. So they say Todd Blanche is not available on Thursday, so that takes out the 10th, since he must appear for a court proceeding in the prosecution brought against Trump in Florida. Yeah, he can't be there on the 10th because he's got another Trump prosecution by this same special counsel in Florida. That's why he's unavailable. Mr. Lauro is available on Thursday with a preference for an afternoon setting. However, since we lost Friday as an option, which means that's gone for some reason, we would respectfully request a setting on Monday after 12 p.m. or Tuesday all day to allow for both Mr. Blanche and Mr. Lauro to be present. So they say Friday's gone. Don't know if they could get there on August 9th. Didn't really address that, which is tomorrow from the day that we're recording this, so it's short notice. The judge wanted everything done by the 11th, 2 times before the 11th, and they gave dates after the 11th. So they gave the following Monday and a Tuesday, which are obviously far after the 11th. So the judge could really set it on any of them other than Friday. And again, I don't know why Friday isn't an option. So, all right, this is how it works, right? We've got it back and forth. And the government, I think, is just slapping this in there. They're like, hey, judge, you can figure it out. This is what we're working with, okay? We're dealing with Trump's lawyers, and look how complicated this is. They're irritated that we're prosecuting him in Florida. So they're using that as an excuse. He's got 2 lawyers, All right, so that's the notice. Now, if they get to the hearing, if the judge doesn't do something differently, this is what they're going to be arguing about, a protective order. And remember how this format goes when you're filing motions? The government went first, so they file the motion. The motion goes in first. Then Trump files a response, so that goes second. And then the government gets the final say. So if it's a sandwich, the government's the final one on top. Right? Government goes first, something else in the middle, government's on top. This is their reply. And they've already asked for a protective order. They say Trump's a maniac. He's threatening everybody on Truth Social. He posted a bunch of stuff. John Lauro also hit a ton of the news stations on Sunday. And we said that that was by design. Okay, that was strategy. A lot of people on the left were saying, Trump's a maniac. Look at him. He's like 13 truths in like 3 hours. Oh, what a psycho. We're going, hey, dum-dums. You're missing the whole show here. This is by design. He is exercising maximum extension of free speech. It's like a force field. You go and you claim your territory. He's claiming free speech all over the place. Going on CNN claiming some. Going on Truth claiming some about Fannie and Tishy and Alvin and all of these prosecutors with his ads, right? He's gobbling it all up. So the government said, we want a protective order. He shouldn't be able to do basically anything. Talk about any witnesses, talk about any evidence. And then Trump's people responded and they said, that's nuts. This isn't a classified documents case. The government's calling all this stuff sensitive information. What's so sensitive about this? This is the January 6th insurrection. Why can't we see all the evidence, quite frankly? I would like to see even the grand jury stuff, which we generally don't get access to, but I'd love to see it. Why not? It's a matter of public importance. Historic, as they keep saying. So why can't we see the historic internal mechanics? So this is the government now finally responding. They say, all right, Judge, I know you want us to have a hearing, but they're going to say there shouldn't even be oral arguments on this. In other words, they don't want Trump to even speak about a protective order which limits his ability to speak. You see how psycho we are in this current environment? The judge wants a gag order issued, a protective order issued, without even affording Trump the opportunity to speak. He should be gagged from arguing the gag order. We'll get there. They say this is the government bureaucrats for Biden and his prosecutors who are prosecuting Trump. Let's not forget that. Biden, Pelosi, the Democrats, they've all been choreographing this for years. So Jack Smith writes, the central purpose of criminal discovery is to provide Trump with materials necessary to prepare for trial. To facilitate the efficient production of discovery to the defense, the government proposed what they say is a reasonable protective order consistent with current practice in D.C., which nobody really cares about. I mean, obviously D.C. is where all the J6 cases are happening. Trump instead proposed an order designed to allow him to try this case in the media rather than in the courtroom, which they would absolutely hate. They know that they've got this rigged jurisdiction, and Trump is effective in the media. He's not going to have the same tools in the courtroom. So here's their big justification for why Trump should be silent. To safeguard witness privacy and the integrity of these proceedings, the court should enter the government's proposed protective order. Just enter it, right? Don't wait for hearings, just do it. And these are their justifications. And by the way, I'm all for witness privacy. Okay, protect their privacy, protect their identities, protect their personally identifiable information and all of that. I don't want anybody threatened or intimidated or tampered with at all, including the defense witnesses. I don't want prosecutors like Jay Bratt to put pressure on Mr. Woodward, who's representing Walt Nauta, saying that if your client doesn't work with us, you might not become that superior court judge you want to be. So we want that across the board. I wish the DOJ complied with that. But we also want access. We want transparency. So background, the government filed its motion for a protective order on Friday. They were flipped out that Trump was posting truths, exercising his free speech. On Sunday, August 6th, defense counsel John Lauro, Trump's lawyer. Listen, they're so irritated. He appeared on 5 television programs. Oh my gosh. And he discussed the case in detail. That was, again, by design. Both sides. Trump was going hog wild on True Social, just like, blah! John Lauro's going all over the media, doing the same thing. Beautiful. Tag team the whole thing. Talking about everything. Publicly commenting on topics, including the parties' disagreements over this protective order. The defense's planned legal arguments. The defendant's actions and statements during the charged conspiracies, and the expected testimony of a prospective witness. Oh man, they're furious. And Trump's people are trying to get it all out there before they get locked down. And then when they do get locked down, when the judge issues a protective order, I would imagine they're preparing some sort of an appeal to some entity to say that our free speech now in the middle of a campaign is being tampered down. We're being censored in the interest of this criminal prosecution from an illegitimate DOJ. For instance, regarding the protective order, defense counsel stated, this is what one of the lawyers said on CNN, John Lauro, says this protective order that's being suggested by the Biden administration is an effort to keep from the press important non-sensitive information. And we will not agree to keeping information that's not sensitive from the press. Shout out to John. Good call. The press should care about this. The press and the American people in a campaign season have a right to know what the evidence is, provided that this evidence is not protected otherwise. Totally. So we're going to oppose it. But for whatever reason, these lawyers and the prosecution team, they want to keep that from you. Government prosecutors are whining, saying, a defense counsel then suggested that the government, by its proposed protective order, was trying to impinge on the freedom of the press. And prosecutors, they get irritated. They're like, no, we didn't do that. On ABC, John Lauro said, this is an attack on you and members of the press. I'm really surprised you haven't spoken out about it. What the Biden administration is trying to do is prevent the press from learning about exculpatory and helpful information. Evidence that the people have a right to know about. What the position of this prosecutor is non-sensitive, ordinary evidence should not be disclosed to the press. John says that's shocking. Not only do they want to violate Trump's First Amendment rights, they want to violate your rights to the freedom of the press. And I'm surprised the major networks aren't filing papers right alongside me on Monday. He suggested he could get ABC, the reporter, the lawyer, to engage in litigation over the protective order. Then John went on to NBC. He says, well, I'm shocked. And I can find you a lawyer to address this, but I'm shocked that all of the news media outlets aren't protesting what the government is trying to do. They hate that. They're like, what are you talking about? We're the good guys. They're trying to say we have discovery that's not sensitive. But we don't want the press to hear about it. And Mr. Trump, our team is saying, President Trump is saying, if there's evidence out there that the government has that's exculpatory or informative, then the press has a right to know. But the Biden administration doesn't want the press to know that. And I'm shocked that there aren't petitions being filed right now opposing what Biden is doing. Says we're all in favor of protecting sensitive and highly sensitive info, but it's unprecedented to have all information hidden in a criminal case, including, by the way, information that might even be exculpatory, that might exonerate Trump. The Biden wants to keep that from the American people. He went on Fox, said the same thing. He says the Biden administration wants the judge, now talking about the judge, to put in place an order that might prevent the press from obtaining exculpatory material. Trump has argued from the very beginning, as I have, that this is an attack. This indictment is an attack on First Amendment rights. Now that the Biden administration wants to deny all Americans the opportunity to learn about non-sensitive info in the middle of a political season. Lauro said, I'm convinced the Biden administration does not want the American people to see the truth. And they acted on it by filing this order, which is an effort to keep important information from the press. I'm shocked. You haven't filed pleadings. The American people have a right to know, but Joe Biden doesn't want this to happen. Prosecutors furious. They're like, wait a minute. We can't get out there and make these statements, right? They can't go out there. Prosecutors, to be fair, they can't go on Fox. Merrick Garland's not going to go on Fox and talk about the case. They've got policies. No, we can't talk about it, blah, blah, blah. So they're very upset that Trump is using this tool and using his free speech. And they don't want that to happen anymore. So they say, okay, Judge, in television appearances, Trump's lawyers also made specific claims about what Trump allegedly said and did during the charged crimes. And he discussed the testimony of Mike Pence that is anticipated. He said Pence is going to be one of our best witnesses, baby. The vice president will be our best witness. We'll get to that in a later segment. On Sunday, the parties conferred twice by phone. Trump's lawyers also shared a red line of the government's order. And with the parties unable to reach an agreement on the order, Trump filed his proposed protective order on Monday, and we read through that briefly. Now, they say Trump himself made a number of social media posts on Truth. For example, the day before his lawyer made comments about Pence, Trump called him Little Mike Pence, a man who was about to be ousted until he came over. He says, I never told a newly emboldened Mike Pence to put me above the Constitution or that Mike was, quote, too honest. He's delusional. Now he wants to show he's a tough guy, flagging that for the judge. And so they say, Your Honor, Trump's order, if you grant Trump's order, it would lead to the public dissemination of discovery material. Okay, who cares? That's great news. Hey, by the way, all of this evidence, all of this discovery material, you say is going to incriminate the most serious insurrectionist, the most serious threat to American democracy since the Civil War. So what are you so freaked out about it? Maybe because it's garbage, which is why it explains why you never charged him with seditious conspiracy. Indeed, they say that is Trump's stated goal. Trump seeks to use the discovery material to litigate this case in the media. It's better than your corrupt courts. It is an election season. One of the biggest issues in the country is about the weaponization of the DOJ to prosecute political enemies. Other countries' leaders are commenting about it. Like, what's going on over there? But that is contrary to the purpose of criminal discovery. Okay, so they're going to hew back to the rules, which is to afford defendants the ability to prepare for and mount a defense in court, not to wage a media campaign. Here's the judge, this is just like any other criminal case. They say the court should instead enter the government's proposed order. Don't even want to talk about it. The government's proposed order, applicable to all discovery, all of it, produced by the government, is very consistent with other criminal cases in this district, all in the corrupt DC district. They reference a bunch of cases. And look, they've got Bannon's case. We also shut him up, so he couldn't talk about it on his podcast. So Trump should also be shut up. But I'll tell you this, he's not running for president. Neither is Peary. Neither is Edwards. Trump's principal objection, they say, as Trump's lawyers stated publicly and in conference with us, the prosecutors, is that it would not permit Trump or his counsel to publicly disseminate, publicize various materials that they get from discovery. But they say there is no right to publicly release discovery material. because the discovery process is designed to ensure a fair process before the court, not to provide them with an opportunity to talk about this in the court of public opinion, which is true, right? This is all true. The court established rules for the courts. They're not necessarily concerned, I mean, to be perfectly fair, with a public election. They're not supposed to be. They're supposed to be separate. And so they're just going to take that right back. Now, this is why this is a problem, because the judge can say, in her opinion, that I agree that this is improper. And she can say, this is how it works within my equal power, my governance, my jurisdiction, which is the judicial branch. Trump is running to control the executive branch, a separate but co-equal branch. And at this moment in time, many polls show him in favor to win that. So a separate co-equal branch of government, if he runs the whole thing, we're going to run directly into this constitutional crisis that we've been concerned about. And you can see it in slow motion evolving right now. So they're going to try to limit him because of criminal courts while crapping all over, to excuse my language, his rights to free speech and his right to campaign openly and appropriately as a candidate. Defense counsel stated goal, Trump's goal, to publicly disseminate and discuss this material is contrary to the general principle against pretrial publicity. However, we are not in a general state of affairs. The defendant, they say, Trump's lawyers contend that strict scrutiny should apply. They say that's the wrong standard. They also say it's inconsistent with this district's local rule and the conduct of the attorneys in criminal cases. The court should not enter a protective order that permits such harmful extrajudicial publicity. They're going to try to shut this whole thing up and watch the judge grant it. As an initial matter, the court can and should exercise its discretion with respect to this protective order to prevent dissemination of the material that could prejudice the jury. What jury? Your D.C. jury with 92% Democrats? The district's rules prohibit Trump's lawyer from doing precisely what he has stated he intends to do if he is permitted, which is to publicize the details of this case, included the testimony of anticipated witnesses. They go right back to their local rules. They say, according to the rules, it's the duty of attorneys in criminal cases not to publicly disseminate information or opinion about the existence of any statement by the accused, testimony of prospective witnesses. These statements might risk tainting the jury pool with inadmissible evidence, or it could harm the integrity of the proceedings. What integrity? The court, they say, should not grant a protective order that would allow Trump to disseminate evidence like snippets of interview recordings, no matter how short, misleading, or unlikely to be admissible they are. Such conduct has the potential to unnecessarily inflame public opinion, short of all the relevant facts. Well, they might just tell you a little bit about what's problematic, and they might not tell you the whole story, and they could intimidate witnesses, and they could pollute the jury pool and degrade the integrity of the proceedings if we know what they're doing. The goal of Trump's proposed order is antithetical to the interests of justice, which nobody believes for a second is going on here, which is why people support the tactic. It's a separate branch of government. It's basically a separation of powers issue. If the entire, entity is corrupted, Trump is running to regain control of the executive branch. In addition to the general principle that the court should enter a protective order, the government sets forth other deficiencies in Trump's proposed order. In paragraph 1, Trump proposes replacing this language with this language. They say the problem is that would allow Trump to obtain sensitive information and publicize those information about trial subpoenas. The government's proposal would prevent that. They say that the defense might interpret this portion to say that they might be able to talk about other people who should be protected against being talked about. In a meet and confer call, Trump's lawyers stated that it's their intention to say that apparently any volunteer, interns, anybody could get access to the discovery. They say that's too broad. Trump's lawyers want to remove the definition of sensitive materials. So these are not classified documents or anything. This is just a January 6th case. But they've labeled everything sensitive materials. This includes discovery transcripts, audio recordings, witness interviews conducted outside the grand jury process. He says, I want to publish that. But they say, nope, the court should reject that stuff. They also want to remove redactions requirements. They oppose that. And some labeling provisions. In conclusion, the government says the government, Your Honor, has proposed a standard, reasonable order that will streamline the flow of the discovery. Trump has proposed an unreasonable order to facilitate this in his plan to litigate this case in the media, which we'll see if he continues to do that. To the detriment of litigating this case in the courtroom, they say normal order should prevail, and listen to this. No oral argument is necessary. We don't even want Trump to be heard on this. The court should enter the government's proposed protective order. Don't even let Trump speak. Just do it. Gag him and make him gagged from arguing the gag. Signed by Thomas Windham and Molly Gaston, so-called prosecutors fighting for justice in America, saying that Trump needs to have his voice removed lest they be exposed for their corrupt hack prosecution right in the middle of an election season. They could have brought this years ago, and we wouldn't have had that election season argument. But they want to do this under dark of night. They want to do this undercover because that's how they operate. They're bullies and cheaters. They censor and they silence. And they're going to run into a big problem here because if they try to shut Trump up, they have an enforceability problem. What happens if he doesn't comply with that order? What's the judge going to do then? Of course, we're going to continue to follow, my friends. Thank you for subscribing as we continue to cover.